And a legal battle is underway in Missouri after its Secretary of State blocks petitions for a referendum on the state's fetal heartbeat bill. One America's Jacob Demille explains.
Pro-abortion groups sign a lawsuit against Missouri's Secretary of State after he rejects calls for a referendum vote on the state's recently passed abortion law. On Thursday, Secretary of State Jay Ashcroft said Missouri's constitution prohibits a referendum on the bill, which bans nearly all abortions after 8 weeks of pregnancy. While the rest of the motion won't take effect until late August, a clause requiring minors to have consent from both parents before receiving the procedure was enacted immediately after it was signed by Governor Mike Parson last month. According to Ashcroft, that clause is essential for protecting immediate health and public safety, which disqualifies it from the referendum process.
It was deemed necessary for the immediate preservation of the public health, welfare, peace, and safety, and is hereby declared to be an emergency act within the meaning of the Constitution. Because of that declaration by the legislature, and because of the responsibility of the Secretary of State's office to follow Missouri Supreme Court precedent and the Constitution, we have no other avenue but to reject Referendum 1 and Referendum 2 for failure to comply with the requirements of the Missouri Constitution.
Immediately after the decision, the Secretary of State's office was sued by the ACLU. In the lawsuit, the group asked for a restraining order and preliminary injunction while the court reviews whether Ashcroft's actions are legal. The ACLU also called Ashcroft's decision a sad and cynical ploy to deny Missourians of their constitutional right to petition. However, Ashcroft made it clear that he was simply complying with the interpretation of Missouri's laws by the Supreme Court.
What I would say is we have to follow with the courts. We are a nation and a state of laws and not of men. If I make people unhappy because I do what the law says, that's what's going to happen. The Constitution does not allow a matter to be referred to the people if it meets the criteria that were involved in that emergency clause.
Ashcroft went on to clarify his office does not have the legal authority to decide whether an emergency clause is a true emergency, and said that decision is ultimately left to the courts. Jacob Demille, One America News.
Want to see more videos like this? Click on the link below and subscribe to One America News on YouTube, and call your cable provider and kindly demand that One America News is added to your lineup. Call and subscribe today.